Hey guys, this is Vijay Dinakar. Today I want to talk about the so-called rising blood alcohol defense. So in California, there's two separate DUI statutes, California Vehicle Code Section 23152A, and that's driving under the influence of alcohol, and California Vehicle Code Section 23152B, and that's driving with a blood alcohol level of 0.08 or higher. So the rising blood alcohol defense relates to the second charge, 23152B, and that basically goes to the point that it is illegal to drive with a blood alcohol level of 0.08 or higher. It is not illegal to have a test of 0.08 or higher. So to give an example of the difference between the two, let's say somebody's driving at midnight and they are seen by the officer at that time. They're pulled over at midnight and the officer begins a in-field DUI investigation. They ask all kinds of questions. Maybe they do some field sobriety tests. At some point, an arrest is made, and then the person is not actually tested until about 12:45, so 45 minutes after the officer saw the person driving. And at that point, the test reads 0.10, for instance. So that's obviously over the 0.08 limit. But the question is, what were they at the time of driving, not at the time of testing? And the answer is, we actually don't know. The government will attempt to say that the blood alcohol was actually lowering. So in other words, at the time of testing, that inaccurately measures a level that is lower than it would have been at the time of driving, but we have no idea if it's actually lowering or raising. So that actually raises the issue of the rising blood alcohol defense. To better understand the rising blood alcohol defense, I want to give a more extreme example. So let's say that somebody's going to a club or a party, and before that, they do some pre-gaming, meaning they drink a large amount of alcohol before going to the party. So let's say right before they get into their car to go to the party or club, they take a large swig of vodka, okay? And then 3 minutes after doing that, while driving, the officer pulls that person over, okay? The question is, at the time of driving, what would their blood alcohol level be? I think you can understand that after just having consumed the alcohol, that alcohol has not traveled through their stomach, through their small intestine, and has not reached what we call full absorption. And so clearly they would, if they were tested at the time of driving, be significantly under the 0.08 limit. But by the time they're actually tested, so for instance, in a half an hour, 45 minutes, 15 minutes, an hour and a half, and those are all very reasonable time differences between the time of driving and the time the officer is able to transport the person to the jail and actually have them submit to a breathalyzer or blood test. At that point, depending on how much vodka they had in that large swig, they could be well over the 0.08 limit. So this is the rising blood alcohol defense. Now, how is the prosecution going to try to show what level you actually were at the time of driving as opposed to the time of testing? Because there's always going to be this time gap. They do something called retrograde extrapolation. So in order to know what you were at the time of driving, they extrapolate from the time of testing. They use some assumptions. And one of the assumptions they have to make is that you were fully absorbed at the time of testing, such that the maximum alcohol concentration that you consumed had reached its height. And then at that point, you're eliminating alcohol. So in other words, your alcohol is coming down. And so that's a huge assumption. We actually don't know if you are actually fully absorbed. Number one, we also don't know what your specific elimination rate is. Now, there's some estimates about how long it takes for a given quantity of alcohol to be fully absorbed in the blood. So what is the actual absorption rate for a given quantity of alcohol? Well, there's actually a huge range among individuals. It can be anywhere from a half an hour to 3 hours for a given quantity of alcohol to reach full absorption. And there will be actually no specific knowledge about, in a specific case, what the actual full absorption rate was. It could be half an hour, it could be an hour, it could be an hour and a half, it could be 2 hours. A number of factors affect the absorption rate: genetics, gender, whether someone consumed food with the alcohol, whether someone consumed water with the alcohol, the type of alcohol they consumed. So when the government's trying to make a retrograde extrapolation and they're making an assumption of full absorption, they are making a lot of assumptions. Now, the second factor that goes into the retrograde extrapolation is the elimination rate. And what's the elimination rate? Again, it's a range. And you'll hear that it could be anywhere from a 0.01 to a 0.06 elimination rate or burn-off rate per hour. There's also a lot of factors that affect the elimination rate, but I think you can see that it's very difficult for the government to actually prove what you were at the time of driving as opposed to what you were at the time of testing, unless they have with them facts about when you were drinking and how much you were drinking. So that's why it's extremely critical for your defense, and hopefully you follow this, that you do not make any statements to the officer. And I've made previous videos both about DUI and other crimes about why you should not make any statements to the officer. But it's especially critical in this case of rising blood alcohol defense. Because going back to our hypothetical, let's say, again, the person had just taken a very large swig of vodka, they had just gotten on the road, and the officer just pulls them over. And the question the officer will say is, "Sir, I smell alcohol on you. Did you drink?" And then the follow-up question is, "When did you drink?" And the follow-up question to that is, "How much did you drink over time?" Now, a lot of people, in trying to interact with the officer for a DUI investigation, are trying to prevent an arrest, and the officer makes that person think that an arrest can be prevented by suggesting that if you're only cooperative and you give me the answers I want, I'll let you go. And so that person may say, "Oh, I had drinks only a couple hours ago, and I had it over a period of time, and I consumed food with that." So in other words, that person is not giving an accurate statement, but they're giving a statement which they believe will help them. Actually, it'll hurt them, because now it's foreclosing the possibility, the very factual and real possibility that they had with the rising blood alcohol defense. Because that large swig of alcohol at the time of driving clearly would not be 0.08 or higher. But at the time of testing, it may well be, and the officer and the government will try to say that, no, you had your drinks well before you got in the car, and you had them over a period of time, and your alcohol level was not rising, it was lowering. So I think I have basically covered the issue of the rising blood alcohol defense. It's a highly effective defense. I've won successfully with this defense at trial numerous times. If you have any other questions about DUI, let me know. Take care and all the best.